Thank you for joining us. The following presentation is from a webinar titled How to Avoid 401k and Pension Plan Disasters, originally produced on April 23, 2015. The presenters are Daniel Sturm, Shalane Cohen, and Danielle Ginter, all from McKonly Asbury. Enjoy the presentation and visit us online at www.macpas.com for more information about our future events and upcoming webinars.
Thanks, Tyler, and thanks for our audience for joining us today. We hope this webinar provides a little bit of something for everyone. We don't want this to be overly technical. We have a lot of information to get through, but again, we hope to have a little bit of something for everyone. My name is Dan Sturm. I help lead the M&A Employee Benefit Plan Audit practice. Been here for about 8 years, and I have about 13 years of experience auditing employee benefit plans.
And I'm Shalane Cohen. I've been with McKonly Asbury for about 10 years and in the employee benefit practice world for about 7.
And I'm Danielle Ginter. I'm a senior manager with our audit segment, and I've been with the firm for about 9.5 years and have been doing employee benefit plan audits that entire time.
All right, thank you. We're actually going to kick things off with a polling question. Not start too soon, but we just want to get an idea of our audience and see who's on the call.
Looks like a lot of you are responding already. We'll give everyone just a little bit more time to respond.
All right, great. Looks like the mix we expected. A lot of folks joining us from human resources, finance professionals. So good. We think we have a little bit for both of you on this call, as well as some others. The objectives of this webinar: we want to learn how you, your management, HR team, finance team, basically all involved with the process, can prevent some costly mistakes associated with running a 401k plan or a pension plan. We also want to help teach you the steps to take when sponsoring a retirement plan, possibly avoid some of these problems down the road, not deal with them after the fact, and also learn what to do when you come across a problem that has already happened. And with that, I'm going to turn it over to Shalane.
All right, thanks, Dan. First of all, I'm an auditor, so I love numbers. So we're going to start this off here at the beginning with some statistics from the DOL. The DOL gives authority to enforce ERISA to what's called the Employee Benefits Security Administration, and that's also referred to as EBSA. Throughout this presentation, I will interchange EBSA and DOL, since most of us are more familiar with DOL, and that will sound more familiar to us. So here are a couple statistics that I thought was interesting. The DOL's authority to enforce ERISA extends to nearly 684,000 retirement plans. These plans include both health and other retirement plans, and they cover about 141 million workers and their dependents. And those assets of those plans are over $7.6 trillion as of October 2014, which I just think is a huge population to oversee. As part of this enforcement, the DOL performed almost 4,000 civil investigations, with about 2,500 of those cases resulting in monetary results for plans or other corrections. In 2014 alone, they recovered almost $600 million for direct payments to plans, participants, and their beneficiaries. And I guess kind of the scary part is in 2014, they had indictments of 106 people for crimes related to employee benefit plans. I'm sure a lot of us don't think of indictments when we think of employee benefit plans, but it does happen. So as an audience, some of you may be wondering why you should care about this and these statistics, but the point is that they're enforcing these regulations. And on the following slide, I have some examples of the civil violations that they're finding. The first one that they're seeing, first, EBSA conducts investigations of both civil and criminal violations for benefit plans. Criminal violations would include things such as embezzlement, kickbacks, false statements, and those are the things that you would hear about on the news or in the articles that you're seeing. But based on the numbers on the previous slide, it seems like more of their efforts are geared toward the civil violations. So that's why I'm focusing on these civil violations here, and we'll look at some of the criminal ones a little later. The first one we see is failing to operate the plan prudently and for the exclusive benefit of the participants. And where plans run into problems is when plan management gets their priorities mixed up, whether for personal or the employer or plan sponsor, and they don't keep the participant as the first and foremost priority, which it should always be. The second one would be using plan assets to benefit related parties to the plan. This could be anywhere from the plan administrator, the plan sponsor, or any parties related to those individuals. In general, plan assets should not go to related parties or parties in interest unless it's required in order to operate the plan prudently. So just no unnecessary transactions with these related parties. The next one they see is failing to properly value plan assets at current fair market value. This may be more familiar with those on the call that are involved in finance. So it's important to have finance and HR working together on this matter. I would imagine that this is probably more frequently found when you have hard-to-value assets. So in a defined contribution plan, it would be if they had a real estate investment or something. And for an ESOP plan, I would imagine this would be in the case of valuing the employer's stock, which should be valued by an independent third party. But there's some subjectivity there, so that's an area where they're seeing violations. The next one is failing to follow the terms of the plan. And they do include a caveat unless it's inconsistent with ERISA. Anyone on the call who's involved in the setup of their plan, I hope that you had an ERISA attorney involved so that you can make sure that it's ERISA compliant. If that's the case, you should be in compliance as long as you follow the terms of your plan. And this could range from plan comp to vesting percentages and a whole plethora of other things. Lastly, I have here failing to properly select and monitor service providers. And we'll go into this in a little more detail later about selecting and monitoring those service providers. But it's important to note that selecting and monitoring them is the plan's responsibility. So just something to keep in mind.
I think probably the common theme with all these, and it's how we approach our audits here at McKonly, is whenever we're looking at a plan, it's all participant focused. It's not necessarily what's the balance sheet look like. Basically all these violation examples are looking out for the participants. They want to make sure a participant, you as a plan sponsor, are taking on the responsibility to invest your employees' money and offer this benefit. They want to make sure that benefit is being provided and the participants are being looked out for. So that's the one common theme I see throughout that list.
Thanks, Dan. Now, as I mentioned previously, the breadth of participants and the plans that the DOL and EBSA cover is pretty expansive. So it makes sense that the DOL establishes priorities and specific projects to focus their efforts. Right now, they have two national enforcement priorities that I want to talk about. The first is the major case enforcement. And as part of this priority, the DOL's goal is to focus on enforcement resources towards areas that have the greatest impact on protecting plan assets and participant benefits. Starting in 2013, they strategically focused more investigative resources on any professional fiduciaries or service providers who had responsibilities for a large amount of plan assets or administration of plan benefits. So the takeaway from that is I think if you're an administrator or a fiduciary of a large plan, they may be focusing on you. So just something to keep in mind. The second one is the Employee Contributions Initiative. The DOL has had a long history of protecting employee contributions, healthcare, and other contributory plans. We've seen the enforcement in practice in industry as they're cracking down on the delinquent employee contributions over the last few years. If you're a client of ours currently, I'm sure you've heard us talk about this, so I won't go into a ton of detail because we've been harping on this for a while, but just know that it's critical to remit your employee contributions as soon as possible, and then once you've established that, to stick with that time frame. If you go to the DOL's website, there's a whole site dedicated to all the cases related to this initiative, and it's kind of scary to see the laundry list of cases that date back to 2010. So they're on the lookout for that, so be aware. So as they focus their enforcement resources, they want to have the greatest impact, and they've identified here there's 5 enforcement projects where they're putting their emphasis. The first one is the Contributory Plans Criminal Project. So what's unique about this is the first time that there's been a national project that's solely criminal, and it's designed to target people who commit fraud and abuse against participants. There's a number of ways where they can be vulnerable, both internally and third parties. And internally would be employers using plan assets for an improper way that would harm the participants. Third parties, they would have to be unscrupulous. I like that word. And they gained access to the plan's funds and used it for their own financial gain. So those are the more criminal cases. So hopefully we don't have anyone doing criminal items on the webinar today. The second one is the Fiduciary Service Provider Comp Project. And I'm sure most of you are aware with all of the additional disclosures, both on the 5500 and to the participants, that this has been a focus. And this project complements all of those initiatives and just make sure that there isn't any improper or undisclosed compensation to any consultants or advisors of the plan. Next, we have the Rapid ERISA Action Team. And this one just makes so much sense to me. They call it REACT, and it targets populations of plan participants who are potentially exposed to the greatest risk of loss. And an example of that would be a plan whose sponsor has filed for bankruptcy. And what this project does is it enables a really quick response so that the rights of those participants of an employer who's gone bankrupt are protected quickly, because there is the possibility that that plan sponsor, when they don't have cash flow, that they will use the employer's funds in their 401k and they would commingle those with their own plan or their own assets and misuse those funds. And so you could have participants who at the end of the day have no retirement after the bankruptcy. So they're really trying to react fast to that. Next we have the ESOP, or Employee Stock Ownership Plans. And this one's pretty self-explanatory, but it focuses on ESOPs, which are very unique, and either the incorrect valuation of employer securities, or if they don't give the specific benefits required under ESOPs. And that can include voting rights, ability to diversify their account balances after a certain amount of time, and the right to sell their shares of stock when they receive them. Lastly, there's not a whole lot to say about this, but it just notes that EBSA is responsible for oversight of the Voluntary Fiduciary Correction Program. And that's a program that allows plan administrators to correct violations that they've identified. So they have a lot going on, a lot of projects, so don't be surprised if you're a large plan, an ESOP, or if your plan sponsor files bankruptcy, if you're hearing from the Department of Labor.
Yeah, and I think with ESOPs, as I was doing some research for this presentation today, I did notice a couple cases, and to my knowledge, I don't think they've went anywhere at this point. But I did read about a couple cases where participants were actually going back to the plan sponsor and questioning things like business decisions, because at this point, now that there was an ESOP involved, some of those decisions may negatively impacted their value in their plan. So, I don't think that they've went anywhere at this point, but if you're working with an ESOP plan, something to keep in mind that those cases are out there. I'd be glad to share my research with them. But I just found it interesting because now the participants have another avenue to kind of go back and question the value of what they're being provided with the ESOP. Moving on, the next slide I called straight from the DOL. And the reason I titled the slide that is because literally I picked up the phone about 3 weeks ago and called a member of the DOL team just to, off the top of his head, just to get an idea of what 3 things, if they were a plan sponsor, would they be most focused on based on their investigations, findings, problems that they've seen. So the 3 things on this slide are essentially what that phone call was about. Number 1, and they emphasized this, and I'm not saying this because we're auditors, but he emphasized auditor selection. He said basically it's one of the most common problems they see and that they have problems with is a plan sponsor selecting a bad auditor. And when I say bad auditor, it means an auditor not qualified to do the audit or maybe not have the expertise to actually do the audit and look for the risks and identify the problems within the plan. One stat he pointed out to me was 70% of the audits for a firm that audited less than 5 plans had problems. It's a big number, and there's a lot of firms out there that audit very few plans, and I think the DOL has proven that you almost need to do a lot of these to see the consistencies, to see the problems, and really help your clients with the risks. They basically, in most of these cases, the first question they go back to the sponsor, especially in major problem areas, and ask, is the auditor capable of doing the audit? If it's that bad, they ultimately are going to come back on the plan sponsor. While there will be some accountability with the CPA firm, they're ultimately going to hold the plan sponsor accountable for their audit selection. If it's bad enough, they may actually have the plan redo the audit. And if that plan sponsor ultimately decides to stick with the same auditor, the DOL is really going to make them demonstrate why they think it's prudent, back to the word prudent that Shalane highlighted, why it's prudent to stick with that auditor. So they're going to look for that information. And one example I'd like to give is basically some language straight out of a letter from the DOL in a request for an audit, or basically audit work papers based on a plan that's been submitted. And what I want to point out with this is they're really holding the plan sponsor accountable. Basically, failure to provide material information will be treated as a failure to file an annual report unless a revised report satisfactory to the department is filed. So basically what they're saying is they got the audit work papers from an auditor. They weren't satisfied with the testing or the auditor's work. They're saying the audit was bad, and now they're basically rejecting the plan's filing. Reason that's important is because unless it's redone within the time frame that they set, meaning the audit's redone or they meet the requirements, they will assess what they call a civil penalty up to $1,100 per day from which the date of the annual report was due. And they also highlight here that will not take into account any extension. So if you get an extension to October 15th, they're going to take it back to that original due date, fine you up to $1,100 per day. And again, in this case, the auditor may have been the one to fail doing his or her job, but this fine is going to be directly to the plan sponsor. So
Dan, if the DOL doesn't come back and do this audit until 2 years after you filed it, would you get fined from July 31st of the year of the filing all the way until you get that report resubmitted?
In theory, yes.
Okay.
I don't see it being that long.
Okay.
They're typically pretty quick to make the request.
Okay.
So you'll probably see requests for 2013 year-end plans now. Unless there's problems, I doubt they're going to continue to go back year upon year. Okay. It's going to be more. But from my understanding, they will work with the plan sponsor to reduce these fines. So while it says $1,100 per day, if the plan sponsor and the auditor work together, provide the DOL the information they need, the fine will maybe reduced to zero or maybe significantly reduced. But I ultimately, like we pointed out, they want these plans to be done right. They want prudent decisions made, and they want all involved doing their job, basically, to serve the participants. And I guess I would reach out to my team here. As far as auditor selection, I know we have a mix of people on this call. What would you suggest they do if they're in the process of selecting an auditor? If they're getting ready to go through there, they have went through that process, where would you recommend they start?
Actually, this is one area where the DOL has kind of got in front of this. So they know they're going to be looking at this, and they've also provided on their website, if you go to the Department of Labor's website, they have an auditor selection guide, and it goes through a whole host of Q&As that you may have as your involvement in plan management. It includes a list of questions that you can ask if you're unsure of what you should know from your plan auditor. So that's a good resource that you can go to if you're unsure of how to go through that process.
That's perfect. And I know the AICPA has resources as well. So definitely a lot of resources out there to help you plan sponsors with checklists and things like that to make sure you're making the right decisions with your auditor selection. The next item he pointed out was the plan document. And I started with the conversation with him of just reading the document. And he actually stopped me and said, no, I'd actually take it a step further. And he said, just making sure, he said, you'd be surprised at the amount of sponsors we contact that can't even find the plan document. So I have not personally seen that where we can't get the plan document. But according to the person I spoke with at DOL, it's very common that he calls and makes a request for information, and they basically can't get the plan document. So that's step one. Make sure you have the plan document. But equally and probably more important at this point, make sure you've read and understand the plan document. We harp on that with our clients to make sure they understand the document, what's in it, what does it say, how does it define plan compensation, basically each piece of that document, because when the DOL comes in to look at your plan, as Shalane pointed out, unless it's against ERISA, they're going to hold you accountable to your plan document. It's not necessarily comparing to ERISA. It's looking at that plan document and making sure you're doing everything you told your participants you're going to do. And basically he pointed out that this is very common that does not happen. Next one kind of goes hand in hand with the plan document. It's plan operations. It's basically making sure everyone knows and they understand how the plan should operate and in accordance with the plan document. And with that, we're actually going to jump into the core of the presentation. And basically, one of the main objectives we had with the webinar was to actually go through some real-world cases. We often preach to our clients of things we think they should do or could help their plan, even though they're more time-consuming. We do end up preaching some of these things. So we thought it was important for everybody on the call to actually go through some cases that we found. And we pulled these cases from the DOL and other various public databases. And if you'd like any more information than what we're presenting on these plans, I'd be glad to share it with you. We're just going to kind of hit the high points with these. The point with each of these cases is that things happen. Things don't always run perfectly. Our primary objective is to point them out and probably give you some suggestions on how you can avoid some of these outcomes that will be brought up in these plans. The first one, I wouldn't necessarily call this a problem or a bad outcome, but it has to do with church plans. And I think we have a couple people on the call that run church plans. And just a little bit of background, church plans are basically exempt from ERISA standards. So they're typical 401ks and possibly pension plans, but they're not necessarily held to ERISA standards. And reason we put this on here is there was actually 2 cases in 2014. The first case basically said if you're not a church, to the full definition of the word, you cannot file under that exemption. Basically, so if you're an entity related to a church, affiliated with the church at any point in time, they're currently may file under a church plan exemption. This first case basically said no. If you're not a church, can't do that. Second case came out in 2014, basically completely contradicted that and said no, the whole point of this exemption is for entities related to churches and things like that to be exempt from being held to these ERISA standards. So point with pointing these out is these things are being discussed. So it is out there. There are cases. I think the second case kind of keeps things where they're at for the moment. But I would ask my team here, would you have any concerns if you were filing under a church plan exemption, and would you do anything differently at this point?
I guess my response would be that if you're a church, I think you're fine filing under the exemption, under the church exemption, and you can sleep good at night. However, if you're a church-related organization, I would just encourage you to proceed with caution. Best practice would be to consult an ERISA attorney and have them research and conclude on whether or not you can file under that exemption. And then another key is to maintain that documentation, just for the fact that if you were to experience the unfortunate event of having a DOL audit, you would have that documentation to show to them to explain why you believe that you qualify for that exemption.
Thanks, Shalane. The next case has to do with a service provider. and I think we have 5 cases total. So we tried to mix up the cases and just kind of point out different outcomes. So again, all this information is public. I'm not presenting any information that should not be out there. It all came from websites. But this had to do with a company called Benefit Consultants, Inc., and it happened in 2014. With this service provider, they stole approximately $4.3 million from 4 different pension plans. And they provided admin services. And think of admin services such as record keeping, payment processing, typical services that you would engage in. The key to this slide that I wanted to point out is, in addition to the $4.3 million that they stole, they were providing false investment statements to basically their consumers. The people they were serving were getting false investment statements for over 4 years. And I look at that, and once you're providing false documents and people are opening up mail and seeing a statement that looks 100% valid, no one really questions it. So I think when I hear things like this, I'd like to ask my team here, what could these plans have done? I mean, this happened for 4 years. What could they have done to prevent some of this? I mean, this would be really challenging to identify.
I can speak to that, Dan. I think it starts with a thorough service provider selection. You want to make sure that you're meeting with several different service providers and comparing the different information that they have. For instance, do you have online access where you can view real-time information? Also, do they have a service organization control report? This you might hear as a SOC 1 report. If they do have this, make sure that you're reading it. And if they have any exceptions, make sure they're exceptions that you can be comfortable with. If they don't have a SOC 1 report, then I think you have to take it a little further. I would recommend maybe asking for an on-site visit, meet with their employees, get an understanding for the different procedures they have and the controls that they have in place.
Now, Danielle, you mentioned SOC reports, and if a service provider doesn't have one, is that necessarily a big red flag for someone using a service provider that doesn't provide that report?
No, I don't think so, because it might not make sense for that organization, depending on who their clients are, to have that. But again, I think as a plan sponsor, you want to make sure that you're doing your due diligence. And again, that's when you would want to go on site with them and walk through their processes. The other thing I would recommend for something like this is you should know what type of information you should be getting from your service provider. For instance, you should be getting investment statements, a listing of distributions by payee and amount, a listing of expenses by payee and amount. If you're not getting this information, or you're getting it but it's not timely, or it's after you've asked for it 3 or 4 times and it's 6 months down the road, these are all red flags that you want to look into.
This next case is another service provider case, and I am in no way trying to pick on service provider. But
we do have at least one on the call. So
yeah, so I am in no way trying to pick on them at all, because we work with a lot of great service providers. But I do want to point out it can happen. And I don't want anyone on the call just assume is everything okay because you signed an agreement, you're getting statements in the mail, everything seems perfect. This next case actually relates to a union plan, and I don't think we have any union plan folks on the call, but I still think it's relevant. And basically what was happening here with this particular service provider is they were processing payments and paying bills. So the point is, this company that they were dealing with had access to plan assets. Ultimately, what ended up happening was they wrote 46 checks totaling $427,000 to friends and family, and the service provider, a professional at the service provider, was splitting the proceeds. So kind of unique, but he was able to take a lot of money out of the plan through this scheme, and it wasn't picked up. This went on, just like the other case, for some amount of time. So same thing. I know similar case, but I would ask my team here, how would you prevent something like this? Like, you engage a service provider, you think everything's going great, and turns out they're cutting checks to people outside the organization.
Yeah, I think that's a hard one. I think you kind of have to go at it twofold. First, I think you have to have some preventative controls in place. So I would recommend to any of our plan management that you be approving expenses prior to your TPA being allowed to pay them, so that you can verify that only expenses that are necessary and prudent are getting paid by the plan. Then on the detective side, because, I mean, if we're honest, if your third-party administrator is perpetuating fraud, they don't care if you've approved an expense. They're going to cut it anyway. So then you have to kind of address it from a detective point of view. And that goes back to something that Danielle was saying about having, timely access to distribution reports to plan participants or listings of plan expenses to make sure that those disbursements that are going out of the plan are real and appropriate for that plan.
I mean, I think the key with all this is just understand the extent of what your service providers are doing, what agreements you've signed. And if they're providing SOC reports, it's a great tool. They've likely spent a lot of money to bring somebody in to do the SOC report, to look at their controls, and to prove to you as a consumer of their service that they have controls in place and they're working. So take advantage of the things that they're providing. This next case probably has a little bit more to do with business owners on the call, and I know we have a few on the call. But the case has to do with an executive, and it was the head of a defense contracting company in this case. So I think the point with this is it adds a little bit of complexity because no one really is in a position at this particular company to tell this person what to do. It's not like, excuse me, not like you have lower level people that someone can be monitoring over. It's literally the top person. So this particular person stole more than $186,000 by taking amounts from employee paychecks and not investing it in the employee accounts. And so they were using the money basically for other purposes, things like a FedEx field suite at Redskins game and sponsorship of a Virginia Gold Cup. So they were basically taking the money for business purposes. It wasn't for personal use directly. It was to benefit the business, but they were still doing it. So this brings up an interesting point. I just assume in this case it's a company. It's not a large company. It's a company with 4 people or so. So resources are limited. You can't necessarily segregate all the duties. How could this situation possibly be avoided?
Well, Dan, even with limited resources, you could still have a retirement plan committee that consists of maybe the owner, an employee, a member of management, a member of a service provider. And if they were just meeting once a quarter or twice a year, they could look at the trust statements and see that contributions aren't being made to the plan. So that would have been caught in this case. The other thing I'd be curious about is, did any employees complain about not receiving contributions into the plan? And I think this highlights why employee education is so important. You want to make sure that your participants understand the plan and they understand what they should be receiving as far as participant statements and whether or not those would be monthly or quarterly or online or through the mail. Because if that was the case, then you would think that an employee would also have noticed that their deferrals weren't being remitted to the plan. And then if they did have any issues, you would want to make sure that you communicate to them where they can go with those complaints. So having someone inside your organization as well as having someone outside of the organization at the service provider that they could contact would be a good idea.
I would further add to that. Would you think it would be any more okay if they were taking these contributions and just using it for general? Let's just keep the business running. We need some money. We have the $200,000 in contributions that are due. Let's just hold them a week and we use it for a business purpose. Does that make it any more okay?
Absolutely not, because it's not the plan sponsor's money. It's not even a little bit their money. It's not their money at all. So they should not be using that for business purposes.
This next case, actually our last case, I found it to be the most interesting.
Before we go into that, can we? We have one more polling question that we want to do.
Good call, Charlene.
Yep. So if you want to take a quick sec to answer this polling question about whether your plan has a retirement committee, we would appreciate it. Looks like everyone's responding pretty quickly.
Looks like we have quite a few I have no idea responses. So I would encourage those responders to maybe give us a call. We'll help you out with that.
Well, and those that said no, I think the takeaway is I think you have an action point for when you go back to your plan and trying to develop, even if it's a very small committee, but just so that there's some accountability.
Yeah, we see all ranges of committees. We see very sophisticated committees that include 10, 12, 15 people. from all areas of the company, and we see committees that are just a couple people. But I think the point with both, they both serve the same purpose of those committees are to look for the plan, look out for the plan, look out for the participants, and make sure they understand everything that's going on with the plan to direct who should be doing what. Now I can jump into the last case. This I found to be the most interesting of the cases when we were doing our research, and the reason I found it the most interesting is not just purely the volume of, there was, as you see, there's $5 million in misappropriated assets from two different plans, but it's how it happened. And as the first bullet point here, or second bullet point, is 12 different occasions, basically a trustee, fiduciary of the plan, and for example purposes, think CFO, called the record keeper at Charles Schwab, and again, public information, was directed to wire transfer assets from retirement plans to accounts he controlled. Ultimately used those funds to renovate a residence, build a pool, buy cars, and basically anything else he wanted at this point. On a separate occasion, the fiduciary directed another record keeper to wire $3 million to an escrow account, and also asked the record keeper to describe the transaction as a fixed income banknote. Point being, once those statements went out to other people, seeing a fixed income banknote as an investment didn't look unusual. When I first read this, I'm like, how could the record keeper not have basically prevented this from happening? But again, it depends on the relationship with the record keeper. A record keeper may just be just that. They may just be a record keeper. So if a CFO or a higher up at a plan or somebody at the plan is given control to move assets, I don't know that this would always be questioned. So, I mean, I think I would look back more to the plan sponsor to know what they have at the plan and who's making the phone calls. So when I first thought this was crazy, after I thought through it, it's possible it could happen. And so what I noticed, there was a lot of breakdowns that occurred for this to happen, especially at this volume, this amount of money, this level of fraud. What would you recommend plans do in this case? Because they basically reached out and had a record keeper move funds out of the plan.
I think I definitely have some thoughts on what the plan can do. And when we first talked about this case, I didn't think that there was anything that the service provider should have done. But looking at this now, the fact that someone specifically asked them to change the way the transaction was described on the statements, I feel like that should have been a red flag to the record keeper that said, hey, this doesn't seem to be okay.
It could have been, but I guess the problem is you never know what that conversation was. You don't know if it was, hey, I'm investing in this for the plan. If you have a huge pension plan, who knows? $4 million may not have been a massive amount of money for this plan. So if a CFO calls up and he's used to talking to this record keeper on a daily basis, and he's like, hey, I want to move $4 million of this into this asset, and it's basically a fixed income banknote. Yeah, it may not have thrown up any red flags.
True. There are some things that I think you can do as a plan sponsor or the plan management. I think first things first, it's important to keep a listing of who has authority to make decisions on behalf of the plan. Most SOC 1s have a listing of user control considerations, and one of the things that I frequently see there is that the plan is communicating who has authority to their service provider. So that's important. In this case, I don't know that would have been caught since an authorized user was the one directing funds. And looking at this, I see this happening more with a defined benefit plan where the plan administrator has complete authority over the investments. And I think it just shows the importance of having an investment policy, and on the back end, having the investment committee monitor it and make sure that what they're invested in mirrors their investment policy. So, and I mean, maybe lastly, if you have a policy where any unusual transactions that aren't normally part of plan operations, you require maybe dual signatures on those so that one person can't act alone to authorize an infrequent transaction. I mean, I think those should prevent a lot of that.
And I think having a good plan advisor out there as well, someone maybe necessarily doesn't control the assets, but is reviewing the plan maybe as an outside party, to just read through your investments in detail, provide advice, ask questions. But I think there's definitely some opportunities out there to have prevented this.
So we are going to shift gears a little bit. We've been talking a lot about the focus that the DOL has had lately, and now we're going to change to the IRS focus. And the IRS focus is on internal controls. And there's a quote that I found recently that I wanted to share with all of you. And this is directly from the IRS, and it says, if a plan is selected for audit by the IRS, the EP agent conducting the retirement plan examination will begin by evaluating the effectiveness of the plan's internal controls to determine whether to perform a focused audit, that is, just look at 3 to 5 issues, or expand the scope of the examination. In other words, based on the strength of the plan's internal controls, the agent will decide to examine more or less of the return than originally planned. So basically what this statement is stressing is if you're under IRS audit and you can show them that you have a strong internal control structure, they may think that your 5500 is at less of a risk for an error and may decide that they don't have to test everything. They only have to test 2 or 3 items as opposed to every single line on your 5500 or on your financial statements. So to help plan sponsors with internal controls and their focus, the IRS has published several articles recently, one of which is a self-audit checklist, which is a great resource for a plan sponsor if you're concerned that maybe you're missing an internal control that you should have in place. And basically, they break it out into 2 sections. They say you should have internal controls that address plan operations and internal controls that address plan document updates. As far as plan operations, that would be making sure you have controls in place to ensure that your plan compensation is being calculated in compliance with your plan document, or years of service are being calculated for eligibility and for vesting in compliance with your plan document. As far as plan document updates, this would be ensuring that your plan document has been amended for any law changes. And to address this, they recommend meeting with service providers on a regular basis, like maybe once a quarter or twice a year, to go through this with them. You know, and it's interesting because I think a lot of plan sponsors may think, okay, I've hired a third-party administrator, so my responsibility is done. But the thing to remember is if you miss an amendment, that's not going to be on the third-party administrator. That'll be on the plan sponsor, and then you would have potential to be fined by that. And to kind of highlight that, in December 2014, the IRS came out with communication problems that they've noticed between plan sponsors and TPAs. And one of them was failure to timely amend the plan or follow the terms of the plan. So an example of this would be, say you decided to change how your plan compensation is going to be calculated, but you didn't tell your third-party administrator, so they're doing your discrimination testing the old way. So then your discrimination testing is wrong. Or say you outsource your payroll and you don't tell them, so then all of your deferrals are being calculated incorrectly. The second one they noticed was failure to review in-service termination and loan distribution forms to make sure they follow the plan terms. I actually thought this one was kind of interesting. So an example I could think of for this is, say your plan allows hardship withdrawals, but you only allow it for 2 out of maybe the 10 reasons the IRS lets you do it. You would want to make sure that your distribution form clearly shows that a person can only take out a hardship withdrawal if they meet those 2 conditions. The last thing they noticed was failure to count all eligible employees in testing. So this would basically be like not sending a complete census to your third-party administrator. Say you have a subsidiary with 10 employees and you, in error, just left those employees off the census. Those were the types of problems they were seeing. The other item that the IRS has been really focused on are 5500 errors. So on page 4 of Schedule H, if you have fraud in your plan, you're supposed to say yes or no and put the amount. So the IRS decided that they wanted to look at a sample of these returns to determine, is there a trend for what's causing this fraud? And a couple of different things came out of it. One was they noted that these plans had weak internal controls. And again, that goes back to their focus on internal controls. The other thing that they noted was that this was selected yes in error. So what happened was plan sponsors meant to put, yes, our plan is covered by a fidelity bond. It's the question right above it. And they said yes to the fraud question. So if you are a plan sponsor and you take nothing else from this webinar, I would strongly recommend doing a thorough review of your 5500. Even if you're having a third-party administrator prepare it, just to kind of prevent these types of errors. The other thing they noted was pension feature codes. And you may not be very familiar with it. They're kind of hidden on page 2 of the 5500. Usually it's a letter and a number, and it basically just notes the type of attributes to your plan. So if you're a health and welfare plan, you would expect to see codes that begin with 4 there. So what the IRS was noting was that several 5500s were having incorrect pension codes put in. And the reason why this is important is this is one of the ways that the IRS determines what plans they're going to audit is by these pension codes. So again, you really want to make sure when you're doing your review of your 5500 that those pension codes make sense and are applicable to your plan. The last 2 bullets, I'll kind of talk hand in hand. So say you have a plan that's terminating. They noticed a few different things. One, they noticed that there would be 0 assets in the plan, yet it wasn't marked a final return. 2, they would notice that it was marked a final return, but there was like millions of dollars in assets and it clearly wasn't terminating. Or 3, it was marked a final return, but there was still $20,000 in assets left, just like distributions that just didn't make it out of the plan yet. You can only mark a final return if your assets are 0. So that's really important to note. They were also noting that some 5500s would put 0 plan participants, but it was an error. Their plan wasn't terminating. Again, millions of dollars of assets. So again, all of these things could have been prevented with a 15, 20-minute quick review of the 5500 before it's submitted to the Department of Labor. So you do your self-audit, you go through your checklist, and you're doing everything right, but you still find an error, which happens under the best of circumstances. So what do you do when you find that? So the most important thing is you just want to be proactive. You want to make sure you correct it before the IRS or the Department of Labor come in and just randomly do an inquiry of your plan. So the first step is to determine, well, what type of error do you have? If you have a plan document failure, this would be like not updating your plan document for law changes. These are one of those errors where I think we would all agree that you should really seek the guidance of an ERISA attorney. And the reason why I say that is it's a lot of documentation, a lot of legalese. And if you're going to submit this to the IRS for correction, you want to make sure it's correct the first time that you send it out. So we definitely recommend for plan document failures to seek the advice of an ERISA attorney. For operation errors, these are typically the ones we see in our audit. And, I don't know, Shalane and Dan, do you want to give an example of maybe an operational error you've seen?
Some of the operational errors that I've seen are not defaulting loans in accordance with your plan document. Also, Danielle, you mentioned previously not calculating plan compensation correctly. So excluding bonuses, or maybe you have a health and wellness bonus if they meet certain requirements, either excluding or including those incorrectly in accordance with your plan document.
Okay. So if you figure out that you have an error, the IRS has great self-correction. So this next slide notes the 3 options from the IRS. You can go through the self-correction program, and this would be for errors that are operational failures, typically not very significant. There's no requirement to notify the IRS. You just go on their website and you follow their outline for correction, and then you keep it on file for in the event that you're ever audited or go under an examination by the IRS. The second option is the voluntary correction program, and this is when you do send paperwork into the IRS and typically pay a penalty. These are typically for operational failures and some plan document failures that aren't very significant. An example of why you would go through VCP versus SCP is an example would be loans. Typically, you can't self-correct loans, so that would be an avenue where you would want to go through the voluntary correction program. And then the last one is the audit closing agreement program, and that would be you're already in the middle of an IRS audit, and they have a finding, it's not very significant. They may allow you to go through this program and pay lesser of a penalty. So that is essentially all we have for today. Oh, except for a polling question.
We keep forgetting
One
about
more.
these
One
polling
more.
questions.
Last polling question.
Everyone's responding quickly. All right, I think we're good.
Yeah, and I think those are about the results I would expect. Probably the number one result was plan operations compliance. And quite honestly, we have those discussions a lot because a plan sponsor may intend or think something's being done a certain way. Plan document was drafted 15 years ago, and that says something different. During that 15 years, positions turn over, people have left, new people have started. So there's some of that lack of familiarity with the plan document and how the plan is operating. So yeah, that makes sense, and those are probably the results I expected to see.
Okay, so I think we just have a few announcements, and then we will answer any questions that you have.
It looks like we have some administrative questions, but we also have a couple questions. So the one that we want to address first is within the presentation, we mentioned VFCP and also VCP. So whoever submitted the question, it looks like, is wanting some clarification between those two, which I can understand because they're pretty similar.
So I can speak to that. The VFCP is a correction program through the Department of Labor, and this is more for fiduciary violations. So this would be as far as late remittances. Late remittances would be something that you would want to correct through the VFCP. The IRS correction program for VCP would be more for operational failures where you weren't in error, you just weren't calculating plan compensation in compliance with the plan document. And the IRS has there's actually a couple of great resources out there for you. The IRS has a fix-it guide. So if you have an error and you're not sure how to correct it, you can go to this fix-it guide and it'll have an error and exactly what you need to do to correct it. And then the Department of Labor actually outlines all of the correction programs, Department of Labor and IRS. So if you know at a high level what your error is, you can go there first and they'll tell you which one you should be looking into.
And I know we've used the Fix-It guide a lot to give advice, and it's really helpful because sometimes it's kind of hard. It seems a little gray between an operational issue or not. So
I would also emphasize with these correction programs, I don't think there's no real risk that it's throwing up red flags for your plan either. Ultimately, the DOL and IRS, for that matter, want you to get these plans right. So if you come forth on your own to voluntarily correct it, it doesn't necessarily mean you're going to get a request for an audit the next week. So these are not out there to scare you. They just want to get things right. I think that's it for our questions. We have a couple administrative questions that we answered along the way. If anybody has any other questions or wants any more detail on these slides, any of the cases, any other information related to plans, any one of the three of us would be happy to help you. So by all means, you have our contact information. Reach out to us. And I thank everyone again for joining us.
Thank you once again for joining us for this presentation, produced by McKonly Asbury. We hope you join us and participate in our upcoming events. You can stay up to date with news and learn more about our upcoming events by visiting us online at www.macpas.com. Thanks again and have a great day.